Okay, question by defense attorney. Did he say whether he attended any school? I don't recall. Well, did he mention college at all? No. Do you recall being interviewed by the police? Yeah. And do you recall whether or not you informed them that he said he went to a local university? Well, from the way he was dressed, I somehow got the impression he was a student. What do you mean, how he was dressed? It just seemed like he was a student. It seemed like he wasn't employed full-time, and he went, from the way he was dressed and not being employed full-time, I assumed he was a student. That might be what it was. Move to strike the last two answers as conclusionary and speculation. Motion to strike is denied. The answers will remain. Okay, Your Honor, for the record, I am returning the revolver into the envelope marked People's Exhibit 15, which is in evidence. Didn't appear he would put a revolver in that package, Your Honor. It didn't seem to that way to me, but it is the only gun that was out. It doesn't have a cylinder to revolve. Okay, now this would be called a Beretta. Is that correct? A weapon, small weapon. I am sealing the envelope and I am returning it to the bailiff. Thank you. Now, how did this person, where did you meet this person that you sold this weapon to? I think he might have come in to buy a mobile home, and he didn't qualify to buy a mobile home. When you say he didn't qualify, what do you mean by that? Well, based on income and past credit history, people are qualified to buy or not to buy. And did he fill out an application? No, not everyone who. Objection, thank you for stopping. The nature of your objection, irrelevant. Well, one takes a broader view that a preliminary hearing is also a time of discovery. I can see that the defense attorney's heart is going pitter-patter at the moment because he has got employment, social security number, and so forth. So in the broad purview of discovery, you may pursue. Please reform your question. Thank you, Your Honor. It is for that purpose, of course. And did he fill out an application with you? No. Did he fill out any sort of paperwork with you? No. I would remember better if he had. I can qualify people just by talking to them a few minutes without going through papers. And do you recall where he said he was employed? No, I don't. Do you recall where he said he was, what income he had? No, I don't. You don't recall any of these, but you do recall that he didn't qualify. Is that correct? Right. So you didn't sell him a mobile home, correct? Right. But you turned around and sold him a weapon, correct? Not at that time, no. When did you sell it to him? At a later date. When was the later date? It was 3 or 4 months ago. Well, how long ago was it that he came into your mobile home place? I don't really recall exactly, maybe 8 months ago. Okay, so then he came into he called me. He did. So you had given him your number. I had given him my card. I give everybody my card. And he called you. What, if anything, did he say? We had somehow gotten into a conversation about firearms when he had been in the first time, and then he called and asked if there was, wondered if I might want to sell. Was his name Alex? No. I don't remember that name that he went by was a first name or last name. I didn't differentiate whether it was one or the other. Now, with regard to this time he called you over the phone, did he come after that phone call? Yeah. And did he look at several weapons? No. We determined by the phone conversation which one he would have. Well, what do you mean you determined by the phone conversation? When he called me, he asked me which one I would sell. I mentioned 2, and then he picked the one. What were the 2 you mentioned? Based on price, I mentioned a 380 also. A 380, what type of 380? It is a AMT 380. May I have, why don't we inquire if he still has that particular weapon? And then we don't have to think it is anything that we have. I just thought he might identify this one. Do you still have that weapon? Yes, I do. Did you ever sell the 380 to anyone else? No. Let me show you another weapon. Well, the court wasn't really saying this is a discovery procedure. No, I understand that, Your Honor. Please proceed. Referring to Q, have you ever seen this weapon before? No, I haven't. I am putting it back in the envelope and returning it to the bailiff. And did he tell you for what purpose he wanted the 25 semi-automatic? Objection, hearsay. Yes or no? Pardon? Yes or no? Objection overruled. No, not that I recollect. Did he pay you in cash? Yes. Did you make any record of who you sold the weapon to? I made out a receipt for his benefit, and he didn't take it, and I just threw it away. But you kept no record for yourself, for your own protection, as to who went off with this weapon. And that was registered to you? No. I have no further questions at this time, okay? One, I am sorry. You see this person sitting to my left? It wasn't him, was it? No. Now, the record shall reflect that at that time, defense counsel was touching the right shoulder of his client, and it is the court's impression that the lack of identification was made by Mr. Martinez concerning the defendant. I have no further questions at this time. Anything? No questions. Mr. Martinez, the court is fascinated by this ability. You have to qualify people as to the purchase without application or anything in writing. Could you tell as best you remember how you did it that day? Well, the fact that he works part-time eliminates him right away, income-wise. And you think he told you he was a part-time employee? Yeah, I seem to recollect that, yeah. And then, of course, he might have owned vast tracts of land and apartment houses, and he had other income? Yeah, I would have asked if he had any other income, sure. And then also, no previous credit history would pretty well shoot him down. How old did you think this person was? Let's see, probably about 28. And no previous credit history? Well, I am not saying that for sure, but if he didn't have any previous credit history, that would eliminate him from being qualified to buy. More typically, you would know from an application where you would ask him to list his Visa, MasterCard. It is a number situation. We run a general ad, and I don't have time to go through an application with him. My time is the only way to make money, so I qualify people real quick. It is easier for me to do it with conversation. If he had previous credit history, I will have him fill out an application and run a TRW, but I can't afford to waste a lot of time on just everybody that comes through the door. Was he alone or with somebody else? He was alone. And are you aware of how he arrived there? Was he driving a vehicle, riding a motorcycle? No, I'm not aware of how he got there. I assume everybody owns a car because I do, but you can't tell us it was a blue Camaro or anything else? No, I can't. Okay, anything further? No. May this witness be excused? One other question. Did he say whether he attended any school? I don't recall. Well, did he mention college at all? No. Do you recall being interviewed by the police? Yeah. Do you recall whether or not you informed them that he said he went to a local university? Well, from the way he was dressed, I somehow got the impression he was a student. What do you mean, how was he dressed? It just seemed like he was a student. It seemed like he wasn't employed full-time, and he went, from the way he was dressed and not being employed full-time, I assumed he was a student, and that might be what it was. Move to strike the last two answers as conclusionary and speculation. Motion to strike is denied. The answers will remain. Okay. Your Honor, for the record, I am returning the revolver into the envelope marked People's Exhibit 15, which is in evidence. Didn't appear he put a revolver in that package, Your Honor. It didn't seem to that way to me, but it is the only gun that was out. It doesn't have a cylinder to revolve. Okay. Now this would be called a Beretta. Is that correct? A weapon, small weapon. I am sealing the envelope and I am returning it to the bailiff. Thank you. Now, how did this person, where did you meet this person that you sold this weapon to? I think he might have come in to buy a mobile home, and he didn't qualify to buy a mobile home. When you say he didn't qualify, what do you mean by that? Well, based on income and past credit history, people are qualified to buy or not to buy. Did he fill out an application? No. Not everyone who, objection. Thank you for stopping. The nature of your objection, irrelevant. Well, one takes a broader view that a preliminary hearing is also a time of discovery. I can see that the defense attorney's heart is going pitter-patter at the moment because he has got employment, social security number, and so forth. So in the broad purview of discovery, you may pursue. Please reform your question. Thank you, Your Honor. It is for that purpose, of course. Did he fill out an application with you? No. Did he fill out any sort of paperwork with you? No. I would remember better if he had. I can qualify people just by talking to them a few minutes without going through papers. And do you recall where he said he was employed? No, I don't. Do you recall where he said he was, what income he had? No, I don't. You don't recall any of these, but you do recall that he didn't qualify. Is that correct? Right. So you didn't sell him a mobile home, correct? Right. But you turned around and sold him a weapon, correct? Not at that time, no. When did you sell it to him? At a later date. When was that later date? It was 3 or 4 months ago. Well, how long ago was it that he came into your mobile home place? I don't really recall exactly, maybe 8 months ago. Okay, so then he came into he called me, he did. So you had given him your number, I had given him my card. I give everybody my card. And he called you. What, if anything, did he say? We had somehow gotten into a conversation about firearms when he had been in the first time, and then he called me and asked if wondered if I might want to sell. Was his name Alex? No, I don't remember that name that he went by. Was the first name or last name? I didn't differentiate whether it was one or the other. Now, with regard to this time he called you over the phone, did he come after that phone call? Yeah. And did he look at several weapons? No. We determined by the phone conversation which one he would have. Well, what do you mean you determined by the phone conversation? When he called me, he asked me which one I would sell. I mentioned 2, and then he picked the one. What were the 2 you mentioned? Based on price, I mentioned a 380 also. A 380. What type of 380? It is a AMT 380. Why don't we inquire if he still has that particular weapon? And then we don't have to think it is anything that we have. I just thought he might identify this one. Do you still have that weapon? Yes, I do. Did you ever sell the 380 to anyone else? No. Let me show you another weapon. Well, the court wasn't really saying this is a discovery procedure. $200 for voice for 15 minutes. Starts with direct by plaintiff. Ready? Mrs. Wayne, you're the plaintiff in this action. You're the Mrs. Wayne I was just talking about? Yes. Pull the microphone up towards you and get it up. You don't have to look at it, just put it up where you're speaking into it. Thank you. Mrs. Wayne, you know the defendant Arlen? Yes. He's the gentleman in the dark blue sweater? Yes. You know his brother Richard sitting behind him? Yes. When did you first meet Arlen? On my birthday, March 21, 1984. And how did you come to meet him? I had gone out late in the evening, decided to spend the day by myself, and I was going to get a Coke or something, and I went to a place that had dancing, and he was there, and he came up and started talking to me, and it was noisy, and he suggested that we go have a coffee. I can't quite hear. Could she speak a little louder? Will your chair go forward any farther? There's boxes under here. Okay. I believe you stated you met Arlen on your birthday in '84. Where was this? Sunnyvale. At the time you resided in Sunnyvale? Yes. You and him went out for coffee? Yes. I think that catches us up now. Do you recall what you discussed with him that evening? We were getting acquainted, so he was telling me about himself and asking me about myself. And I told him where I lived and worked and that sort of thing. Were you employed at the time? No, I had been laid off and I was just starting on some unemployment. Where did you work prior to that? Prior to being terminated? Gill Management Systems. It was a cable TV company in their computer department. Did you and him see each other? Obviously you saw each other. Did you begin dating after your birthday? Yes, the very next day. How frequently did you begin dating? We were together every day after he got off work, about 3 until late in the evening. And he was working up in the Bay Area at that time? Yes. What did he tell you about himself as far as property was concerned? He told me that he owned a house in Simi Valley and that he had bought some property in Cherry Valley just recently. And I don't know if he told me he bought it recently, but he told me he bought some. And he showed me a really long list of cars he said he owned. And just generally, it looked like he was well off. Did you discuss mutual interests with him? He was quite interested in old cars, and I've always been too. So that conversation struck up very easily, and we talked about that a lot. Did he discuss with you any interest in going into the car restoration business? Yes, he did. Your Honor, may I interpose an objection at this time? I'm a little vague as to what time period we're talking about. You might clear that up. For the initial purpose, let's talk about the first couple weeks after you met. During this first couple of weeks, did you discuss any potential business arrangements? Did he discuss any? Yeah. Or we as a, let's start with him. Yes. What did he tell you? He had some dreams of building an auto restoration business. And did he indicate to you that he had some experience in that? He said he's been restoring cars since he was 12 years old. Did those conversations become conversation of the two of you being involved in such a business? Yes, it did. But when would that have taken place? Within the first month sometime. And what were the nature of those discussions? Did you make any determination as to what you were going to do? Well, it was being discussed, but it was probably a couple of months before it was agreed that this was going to be done, and we're going to move forward in that direction. And what was going to be done? Well, it wasn't just the business, but we were going to be together. So we were going to work towards that direction, putting our lives together and working together on something we both enjoyed, and that would be the business. So you were first romantically involved, yes. At the time you met him, what property did you have? You mean like land? Let's start with land. Well, my house in Sunnyvale, 1139 Chander Drive. And how long have you had that property? Approximately 15 years. And would that be property you had with a former husband? For a very short while. But in any event, you were married, and that marriage ended in a dissolution, right? Yes. And out of that dissolution, you retained the family residence? Yes. Do you have a knowledge of the value of the property when you met him? When I met him? Yes. I figured it was worth about $250,000. And do you know how much you owed on it? About $30,000. And had you discussed the property with him during this time, about this property during the first month? Yes. Did you tell him how long you owned it? Yes. Other than that real property of the house, let me back up. What type of house was it? How many bedrooms? 3 bedrooms, 2 bath, a ranch style. Pretty nice house? Yes, it was nice. It had been remodeled. Other than that house and its furnishings, what other property did you have at the time, non-land? I had a car and a truck that were paid for. A 1979 Camaro, I guess it's a Z28 with the fin and fancy hood and all that stuff. I had a 4x4 GMC pickup, 1977, a step side. But what about bank or saving and loan accounts? I had, I guess it was, a savings in Mercury Savings, I don't remember. I had several checking accounts or bank accounts, and I was shuffling them around, so I have myself very confused. May I approach? Yes, any one of the attorneys may approach any witness during the course of the trial. During my opening statement, I remarked to the jury that you had received a substantial sum of money in 1984. That would have been deposited in a savings account? Yes. I'll show you what appears to be a Mercury Savings account marked for identification as Exhibit 4, showing an opening balance of $66,000. Is that the account into which those funds went? Yes. And shortly thereafter, you made an additional deposit of $5,000. Is that correct? Yes. I'll also show you an account statement for, I believe it's Coast Federal Savings. The first statement is January 13, 1984. What number is that marked for identification? Number 3. In March of 1984, and it shows a balance of $13,346. Now, those are sums that you had separate and apart, yes, from the deposit that we just discussed. That is account number 600339. Was there another account at Coast Savings? Yes, I don't know, but I had a savings account, and I might have had as many as 3 accounts at that bank. I had a money market for sure. Let me show you August of 84. It appears that $14,385 was withdrawn from that account and another account in the same amount established. Is that correct? Yes. So the money in these savings accounts is at $14,335 and is essentially the same money. It's moved from one account to the other. Looks like it, yes. So far in Exhibit 3, we have $14,355, and Exhibit 4, we have $66,468, yes. In 1979, you received a letter from Irvine transmitting you a check in the sum of $19,000. Do you recall that? Yes, I do. Do you recall that? Yes. What was that check for? That was for the furnishings from the house fire. You had a fire in your home? Yes. Was there structural damage to the home? Yes, there was. Was the structural damage repaired as part of this settlement? No, it was not. That was handled separately? Yes, through the loan company. So according to this letter, you received the money and of that had to pay $1,300 to your attorneys. I don't remember what the arrangement was with the attorneys. There was the amount requested to be paid to your attorneys, and that was to be paid to them? Yes. So the net proceeds from that would have been $18,500? Yes. And what did you do with that money? I kept it at home because I was looking at real estate and I was considering buying some rental properties and finding some sort of business I wanted to invest in. So you cashed the check into cash? Yes. And you kept that at home? Yes. Did you accumulate any additional cash at home? Yes, I did. How did you do that? Well, just savings, and I don't remember right now. At the time you met him, do you know how much money you had at home in cash? I had some, over $40,000 available, because I thought I would need it to buy something and that the bank wouldn't necessarily let me have it when I wanted it. And so that was your security money? Yeah. Of that $40,000, that was separate and apart from the $71,000 in Mercury savings and from the $14,000 in Coast savings? Yes, also. Up until the time you met him, you had, prior to the time, you worked for this corporation. Is that correct? Yes. They had a stock purchase plan for the payroll? Yes. And you purchased stock from that plan? Yes, I had them take the maximum out of my check. And that is stock that you subsequently sold early in 1985? Yes. I'll show you documents from Charles Schwab indicating the sale of Hewlett-Packard stock in the sum of $21,380. Is that the stock we're talking about? Yes. And that is stock that all this was acquired prior to your meeting him? Yes. And it was separate and apart from the cash of the bank and that Coast Federal Savings? Yes. Also, at the time you met him, did you have IRA accounts in the Bank of America in Sunnyvale? Yes, I did. Let me show you Exhibit 7, which shows them being withdrawn in 1985. Are those your records of those retirement accounts? Yes. One was for $2,500 exactly, and one was for $2,765? Yes. Again, those monies are separate and apart from the ones we've discussed earlier? Yes. Your Honor, at this time I would move to admit Exhibits 2, 3, 4, and 6 into evidence. Do you want to be heard on those, sir? No, Your Honor, no objection. All right. Each of those documents will be admitted into evidence for the number that it bears for identification. 2, 3, 4, 6, and 7, respectively. What is 2? I didn't get that description. I am sorry. I don't think I identified it while I was talking. That is the letter transmitting the insurance check. Fire and insurance proceeds? Yes. How much was that? The net was $18,500. We'll take a noon recess at this time, ladies and gentlemen, and resume at 1:30. You're excused until that time. Now, there is an admonition that I give to the jury each recess, and that admonition will apply whether or not I've given it. And that is, you are not to talk or converse about this case among yourselves or with any person. You are not to let any person approach you about the case. You're not to do any investigation, research, reading, or consultation about the case. nor are you to form or express any opinion about the case to any person until the case has been presented to you and actually submitted to you to decide. We will recess until 1:30. Ladies and gentlemen, there's something the attorneys and I need to discuss on the record outside the presence of the jury. I did tell the bailiff to get you inside, and now I'm going to have to ask you to go outside. We're on the record outside the presence of the jury. I'll indicate for the record the court and counsel have discussed an offer of proof made by the plaintiff. The plaintiff seeks to introduce into evidence the fact that sometime before this relationship between the plaintiff and one of the defendants commenced, her son was killed in a tragic circumstance. I've indicated previously that I did not want counsel to mention anything about it until I've had some time to think about it and until I've had a chance to brief it and make a clear offer of proof that just what it is that plaintiff seeks to introduce. Sir, do you want to make a statement? Yes, Your Honor, and thank you. I acknowledge that all that has happened and I have not had sufficient opportunity to brief the point. My difficulty comes, I'll indicate my difficulty is relevance and whether or not the probative value would outweigh the prejudice. Evidence Code 352, the large portion of our case revolves on major element. A major cause of action is on misrepresentation. Included in it are the elements of knowledge of special circumstances by the defendant and special susceptibility or reliance on the part of the plaintiff. In this case, we show the parties meeting on Mrs. Wayne's birthday, a very depressing time because she had lost her son, and I concur with the court that the circumstances surrounding her son's death, primarily that he was murdered or that it was a death of unnatural causes, would be inflammatory and seek to prejudice the jury. When these parties were dealing with each other, both of them knew that she had recently lost a son who died. And at lunch we were discussing the facts, and I asked her to try to get her to describe what was going on with her. Remember, the thrust of our case is she put $300,000 into this man's hands and loses it. That makes her look kind of stupid. My position is that he took advantage of her situation. If we can't get the simple fact that she had lost a son and was under emotional strain that he knew about and took advantage of, the risk is that she looks to be just, flighty. It would detract from the reasonableness of her conduct. Further, even though I've tried to talk around it in my opening statement, the fact that she has acquired large sums of money, the jury may wonder where that money came from. Did it come from another lawsuit? Is she a perpetual plaintiff? This is a case where she acquired the money on a wrong